Pointed to the language used in Clause 3.1 and Clause 8.1.1. They contend that there was a deliberate use of different expressions in the conditions of service regarding when each of a gratuity and a transport and subsistence allowance is available. The Speaker essentially adopted the same approach. The law on the approach to interpretation is settled. Expressions in a contract are to be given a sensible interpretation. The manner of interpretation does not depend on the person construing an expression. More fundamentally, expressions cannot mean whatever a person may have in mind. The essence to interpretation has been stated as follows. Whatever the nature of the document, consideration must be given to the language used in the light of the ordinary rules of grammar and syntax, the context in which the provision appears, the apparent purpose to which it is directed, and the material known to those responsible for its production. Where more than one meaning is possible, each possibility must be weighed in the light of all these factors. The process is objective, not subjective. A sensible meaning is to be preferred to the one that leads to insensible or unbusinesslike results or undermines the apparent purpose of the document. The judge, when performing the interpretative exercise, is cautioned to guard against the temptation to substitute what the judge regards as reasonable, sensible, or businesslike for the words actually used. The conditions of service are to be construed as a whole, including the subheadings to the document, in discerning the meaning of the expression on vacation of office. The Court has regard to the fact that the expressions on vacation of office and removal from office are related. They both carry the sense of a person at a point no longer being in office. The fundamental question is whether they mean the same thing. I hold that they do not. The expressions are to be construed with reference to their respective subject headings. On vacation of office is used in relation to gratuity, whereas removal from office is used in relation to transport and subsistence allowance. It bears pointing out that an entitlement to transport and subsistence allowance attaches to three categories of events, namely removal from office, vacation of office, and the death of the public protector. I inquired from counsel for the applicant as to why both vacation from office and removal from office are used in relation to the entitlement to transport and subsistence allowance if removal from office and on vacation of office meant the same thing. He submitted that it was surplusage. I disagree. It could not have been the intention that the two expressions meant the same thing when the conditions of service were drawn, more so because that would mean repeating the same description in a listing of bases for an entitlement to transport and subsistence allowance. Allowing a person who was removed from office and a person who vacated their office the benefit of a transport and subsistence allowance shows, in my view, that the conditions of service intended two distinct events to have transpired, namely the vacating of office and a removal from office. The expressions are not synonymous. construing the two expressions as having different attributes makes for a sensible meaning in the context of the conditions of service that on vacation of office and removal of office differ in their meanings. The nature of a gratuity also leads to the conclusion that on vacation of office and removal from office, in the context of the conditions of service, are not synonymous. Gratuity is to be understood as a concept is generally used in an employment context. I agree with the respondents that a gratuity is a token of appreciation as expressed by an employer towards an employee. This view has a bearing on the expression on vacation of office. That is because Clause 3.1 links the payment of a gratuity to vacation of office. It would be absurd for an employer to be expected to pay a gratuity, being a token of appreciation, to an employee who left office in disgrace. The applicant, as stated above, says the legal issue which falls for adjudication is quite straightforward and centered around their interpretation of the relevant clause of the service conditions. The applicant was removed from office on 12 September 2023. She did not vacate her office within the meaning of Clause 3.1 of the conditions of service. Vacation of office, as contemplated in Clause 3.1, means the leaving of office at the end of the term of office as public protector. This is underscored by Clause 3.2 of the conditions of service. Clause 3.2 refers to expiry of term of office as public protector. This underscores that the vacation of office referenced in Clause 3.1 is in relation to the coming to an end of a public protector's term of office, at which point a public protector would vacate office and be paid a gratuity using the formula. Thus, the gratuity to be paid to the surviving spouse is linked to completion of the term of office. I now consider the issue of costs. The parties sought adverse cost orders against each other. The applicant seeks a punitive cost order against the respondent. This includes an order that Ms. Galeka pay costs in her personal capacity. The applicant says that the decision denying her a gratuity is informed by, among others, bias, malice, and vindictiveness towards her by the respondents. She says this is illustrated by, among others, being refused a copy of the opinion referenced by the public protector respondents as informing their view that the applicant was not to be paid a gratuity. The respondents say that the applicant is the one to be saddled with costs on a punitive scale. The speaker says that the applicant attacked a committee of the National Assembly without cause. The public protector respondents say the applicant made unwarranted personal attacks on Ms. Galeka and officials at the Office of the Public Protector, that she did not substantiate the serious allegation that the respondents were biased, and further that the applicant made reckless allegations on oath without regard for the truth. There is much that is regrettable in what the applicant said about the respondents. She did not substantiate the very serious allegations that she made, both in relation to the Office of the Public Protector and the person of Ms. Galeka as a public protector. There was no need for the applicant's intemperate comments against the National Assembly regarding events leading to her removal from office. This court, is not concerned with her removal from office. I have determined, however, that the court will not order costs on a punitive basis. I make the following order. 1, the application is dismissed. 2, the applicant is ordered to pay costs. 3, the costs of counsel are on scale C in relation to senior counsel and scale B in relation to junior counsel. I hand up the judgment. Yes. The court will rise.